Good morning, everybody. I'd like to thank, first of all, Mary and her team for inviting me to speak about my experience as a judge in dealing with domestic violence cases over the last 16 years in the Magistrates' Court in Northern Ireland. I firmly believe that spending time at conferences like this, with an international dimension, expert speakers, committed and interested participants, gives an opportunity to engage, really think and consider about some of the issues and try to tease out worthwhile solutions. I've been asked in particular to address some issues in terms of how the criminal justice system can make progress in how we, the practitioners and in particular judges, deal with domestic violence cases on a daily basis, and how improvements can be made to the entire process and system. I want to spend a little time with you this morning discussing some of the legislative developments in this area and where we are in terms of new legislation and initiatives aimed at keeping people safe and reducing offending, while we continue to make progress here in Northern Ireland at improving how we deal with victims of domestic violence. The judiciary are always willing to look at how the court process can be improved for victims of domestic violence. We don't always get it right. Coming to court and being a witness in a criminal case where someone has suffered domestic violence is extremely difficult. The first thing is that it's an emotional experience. It can be time-consuming, long-running, frustrating, disrupting to work or childcare commitments, and sometimes it quite simply is easier to walk away and forget about pursuing a case before the courts. The issue of how courts deal with victims in cases of domestic violence and the family justice is something which the judiciary are committed to working with other partners in the criminal justice system to explore what can be done to improve things for those coming to court and to encourage people to actually attend to the court in the first place. These are the big issues that we find, certainly when it comes to dealing with the criminal cases. By way of background, for those of you who either don't know me or aren't from this jurisdiction and aware of the work which I do, I'll give you a little bit of background. As a district judge in the Magistrates' Court, me and one of my colleagues may very well be the first judge that a victim of domestic abuse ever encounters. We are there for victims normally hours after an incident of violence has occurred. We are able to provide emergency orders to protect victims and their families and their homes in terms of non-molestation and occupation orders. Then, we very often continue to deal with the same family months after our initial emergency encounter, when we deal with ongoing domestic proceedings and proceedings relating to children of the family. As well as dealing with these family and domestic matters, I, as a judge, deal with perpetrators of domestic violence in the criminal courts and have the difficult task of dealing with criminal cases of domestic violence. These cases are difficult, not because the law which relates to them is complex or novel, but because of the high rate at which victims ultimately fail to engage with the court process and don't turn up to court to testify against the perpetrator of violence against them. As a judge, this can be particularly frustrating, especially when sometimes just weeks or months after a case has collapsed, I often see the same victim and perpetrator before the courts again when the court is required to deal with new allegations, sometimes after the parties have reconciled. Since 2011, the Magistrates' Court here in Derry, under Judge McElhone, has been running a domestic violence special listing arrangement whereby all domestic violence cases are clustered together and heard on the same day each month. This clustering of cases allows the various partner agencies in the criminal justice system to pool their resources and make the court experience a less stressful or traumatic one for complainants. The PPS provide trained specialist prosecutors, victim support or witness service volunteers take complainants through the whole process of giving evidence in advance. In conjunction with Women's Aid, arrangements are made to provide childcare and safe travel to and from court. The aim is to allow the complainant every opportunity to give best evidence they can, free from anxiety. These cases are regularly reviewed prior to the contest hearing to ensure they proceed without any undue delay. These measures were inspired by growing realisation that the attrition rate among complainants in domestic violence cases was much higher than in other criminal cases. In November 2011, 52%, yes, 52% of domestic violence complainants did not give evidence at the contested hearing. After the introduction of the listing arrangements in Derry under the control of Judge McElholm, by July 2014 that figure had fallen to 46.5%. Now, I don't know what the up-to-date statistics are, but the attrition rate is still unacceptably high. And I know Judge McElholm will be able to confirm and expand on that perhaps at a slightly later stage this morning. Far too many complainants are opting out quite early in the prosecutorial process. This is, of course, due to various factors. However, it's important to note that the attrition rate in the Glasgow Specialist Domestic Violence Court is only 10%. In Glasgow, complainants are assigned a trained advocacy support worker within 24 hours of the incident. Quite often, as soon as the police have left the scene, and that the person supports and mentors that complainant all the way through to the conclusion of the prosecution. Here in Northern Ireland, I know victim support and witness services will provide similar support, but it largely depends on the complainant taking a phone call from that agency. If 3 calls go unanswered, that is that. Voice messages, texts and letters are not used, understandably, due to fear of interception by the perpetrator. Clearly, this is not acceptable. Victim support are not happy with this procedure and would prefer to work more closely with the police and other agencies to address this weakness in the system. Last year, we established some problem-solving justice courts here on a pilot basis. I preside over the Substance Misuse Court, which we call the Drugs Court in Belfast. Judge King presided over a family drug and alcohol court in Uri, and Judge McElholm established a domestic violence perpetrator programme problem-solving court in Derry. Very catchy title, as you can tell. However, we haven't seen the results that we had hoped for in Derry, with the domestic violence court and the uptake being disappointingly low, with I think just 6 offenders taking part in the programme. We just weren't seeing the numbers coming before the court. It seems that offenders who came before the courts for domestic violence offences weren't interested in taking part in perpetrator programmes. Either they weren't interested in addressing their offending behaviour, or quite simply they weren't willing to engage with the court. It's clear that we all need to go back to the drawing board to consider what can be done to encourage perpetrators to engage meaningfully in programmes to address this behaviour. Feedback from the perpetrator pilot in Derry was that offenders and their lawyers considered that the programme was all stick and not enough carrot. We need to work hard and think creatively to consider how a domestic violence perpetrator court might be established that would encourage perpetrators to engage. The lack of uptake of the Derry pilot has been very disappointing. However, the challenge is there for us to try something different and to try again. We haven't given up, I assure you, and the judiciary are keen to work with the Department of Justice into the future to see what can be done to make a perpetrator programme solving approach an attractive option, because the aim is really to change behaviour and improve outcomes for offenders, victims and families. It is hoped that the availability of the specialist perpetrator programme post-conviction as a direct alternative to immediate custody will improve the attrition rate when we come to the court cases. It is clear that some complainants simply do not want to play any role in the incarceration of their abuser. They want the abuse to stop, but not necessarily at that cost. We have to recognise the emotional difficulties involved, and this initiative may appeal to some complainants who would otherwise withdraw their cooperation. Time will tell whether this initiative will ultimately be successful, but there is already ample evidence that short custodial sentences have no positive effects whatsoever in changing human behaviour. In the absence of a functioning executive and legislature, the Department of Justice has been working hard to advance certain other key domestic violence initiatives. These are, firstly, the new domestic abuse offence. Although awareness of what domestic violence can entail is increasing, all too often people still associate this with physical violence. However, we need to ensure that people know that all too often domestic abuse involves controlling and coercive behaviour, be it financial, economic or social. Harm that can often be unseen and less outwardly obvious, but which is both serious and life-limiting. For that reason, a new domestic abuse offence has been developed by the Department of Justice, which will capture patterns of psychological abuse, violence and or coercion of a partner or former partner or even close family member. This is intended to reflect the victim experience that all too often abuse is ongoing and non-physical. It will provide for a statutory domestic abuse aggravator, which could attract enhanced sentencing for other offences where domestic abuse is involved. There would also be a child aggravator associated with the domestic abuse offence. While the legislation has been prepared, it can't be taken forward in the absence of an assembly. So at the present time, unfortunately, that has had to be parked. Domestic homicide reviews is the second initiative. Work on the introduction of a domestic homicide review is also well advanced. On average, around 6 people are killed every year in Northern Ireland by a current or former partner or close family member. In providing services and introducing change, a key obligation for us all is to reduce the number of victims. The focus shouldn't stop in the tragic circumstances where an individual dies. For that reason, the introduction of domestic homicide reviews will be a key step forward. And these will adopt a multi-agency approach to identify lessons learned with a view of improving services and helping prevent future victims from coming to harm. The third initiative is the domestic violence protection notices and domestic violence protection orders. The Department of Justice is continuing to prepare for the implementation of domestic violence protection notices and orders in Northern Ireland. They will strengthen police officers' first-line response to victims of domestic violence who need immediate protection and support through placing restrictions on the abuser. The notices and orders will ensure that the police and courts can put protective measures in place for victims in the immediate aftermath of the domestic violence incident. They will place restrictions on perpetrators, for example, stopping them from entering and being within certain distance from the victim's home or making them leave the victim's home. And an order can provide protection for up to 28 days. Similar to the domestic abuse offence, the introduction of the protection and notice orders, of course, requires a return of the Assembly. Domestic violence disclosure scheme is the fourth initiative that has been being developed. And in order to raise awareness and reduce risk to individuals, the Department of Justice has introduced a domestic violence disclosure scheme. This is a police-led scheme that helps ensure the safety of victims of domestic violence and abuse, enabling individuals to make inquiries confidentially to the police. They can ask and potentially get information where they are concerned that their partner may have been abusive in the past. At the end of November, I understand there were over 230 applications that had been made to the scheme. Around 75% of those involved applications from victims or potential victims or third parties who knew them. The remaining 25% have been proactively instigated by the police themselves, where they consider that an individual may be at risk. Finally, I want to mention the initiative of advocacy. This is another significant piece of work being progressed by the Department of Justice in conjunction with their statutory and voluntary sector stakeholders. It's a development of a streamlined advocacy support service which will underpin the range of initiatives that are being introduced. This would provide support to victims of domestic and sexual violence and abuse, regardless of gender, vulnerability, associated level of risk, or despite anywhere where they might live in Northern Ireland. This would also work in tandem with a range of other specialist support services that are currently available, providing a more enhanced and coordinated response to individual need. The ultimate aim of all of these measures is to provide a safer society with fewer victims and fewer perpetrators. These initiatives are all most welcome and will undoubtedly help to convict more perpetrators in the long term. However, the challenge of getting admissible evidence before the court without the oral evidence of the complainant remains the greatest obstacle to successful prosecutions. All of these initiatives only apply if the victim actually comes to court. The frustration that I and my colleagues experience on a daily basis is that the victim very often doesn't even attend the court. And there is an extraordinarily high rate of cases which do not proceed because the victim can't face the court process. To say this is disappointing is a grave understatement. I'd just like to say that in Belfast, I sit in Belfast and probably deal with the majority of domestic violence criminal cases in Belfast. And it is unusual for a domestic violence case to run to contest. They may be listed as a contest, but it is actually unusual for them to run because we just cannot get the victims to attend, the complainants to attend court. And they're therefore being withdrawn, being dismissed, and it is very frustrating. So it is very important that we try to address this issue and turn the oil tanker as far as the mindset and the environment for victims and complainants getting to court. In summing up, I want you to be assured that I and my colleagues in the judiciary are fully committed to playing our part in delivering positive change and positive outcomes in tackling domestic violence in our society. I'd like to say that again, I'd like to thank you for inviting me to come here today, and I know you've had a terrific day one, you're going to have a terrific day two, which is going to be both informative and productive for you all. Now, I'm only sorry that I can't stay for the rest of the day, but what I am happy to do at this stage is to take any questions and allow any discussion that you feel would be helpful, Alison, at this stage.
That would be, I suspect everyone would very much welcome asking some questions. And we have a microphone, as we did yesterday, don't we? Quite hard to see down at the back. Do we have any questions for Judge Bagnall? You may not get the opportunity again. Here we go. Of course.
I hope that when we talk about an advocacy service, it will be in line with our Family Justice Service, because the Family Justice Service will be for every victim and will have, so I hope that we get a special deal in terms of recognising the work that has been done here, and recognising the work of Women's Aid, because we are keen to push. We can do a lot more, but we don't get in there, and we'd like to work closer with the police as well in terms of reaching. The reason the victims they pull out of court is because the support isn't there within ours. If it's there within ours, they will.
Well, the thing that I believe, obviously these are initiatives that are coming from the Department of Justice, so, but I think they would be very naive if they didn't, first of all, listen to those who are the experts on the ground and actually have the experience, and then tap into those resources when they are available and willing to take it up. I do know that from the Glasgow experience, it is crucial to have support for those vulnerable complainants from the very start, and to keep that support going if you are ever wanting to make sure that due process follows through in the criminal courts.
Yeah, because but the lack of legislation, coercive control is a big one.
Absolutely.
Is a big one that impacts on victims' minute.
And the reality is, because of the high rate of victims not attending court, then the mindset and the psyche of the perpetrator is you would never plead guilty to an offence at an early stage, because you have a better than 50-50 chance of this case never proceeding. So why would you ever say, I put my hand up and admit it, and confront the issues that need to be addressed? And that's part of the issue with the pilot, the domestic violence court. So all of these issues need to be confronted and looked at and solved, and then we are going to get a much better environment to allow these cases to be prosecuted.
Another one here.
Well, thank you for your comments. I really appreciate to have an overview of what's happening here. And I'm also very impressed with all the innovative and new ideas you want to try. When it comes to victims not wanting to participate, I think that's a worldwide issue. And I was just curious if there's been any discussion how to prosecute cases without the victim's participation, much like a homicide case, which everyone goes forward on those cases, figuring out how to do that. So where are you in that process?
Well, ironically, I'm actually having a meeting tomorrow with our public prosecution service, and that is one of the issues that we're going to be touching upon. There have been various initiatives which are being tried, and there's still a lot of wrinkles that need to be ironed out, I think is the way to put it. We have now the body-worn footage, which means that the police officer, when they attend an incident, can put on the body a camera and actually record the situation and the distress of a victim and so on and so forth. I think there needs to be further training, for example, as to how the police actually use that. Frustratingly, you might, obviously the incident has occurred generally by that time, you will perhaps have them that they will record what the victim says, but they don't pan the room to show the chaos, for example, that has occurred to bolster the evidence that is on tape. So there are lots of that type of issues that need to be explored, and I think the challenge is for the criminal justice system, to be able to see how you can get good, quality, admissible evidence that can be put before the court.
Thank you.
Because it does have to be admissible evidence at the same time.
Thanks, Judge. Judge, would you maybe say something about sentencing as well? Because that sometimes too can impact on victims coming forward. Because if the sentences aren't serious enough in terms of the seriousness of the assaults, then they sometimes think, well, what's the point really? Mm-hmm. So maybe would you talk a little bit about sentencing? Well,
I don't know whether you all are aware of, there are sentencing guidelines for the Magistrates' Court with regard to assaults. And one of the aggravating factors which is identified within that, of course, is where it has been part of a domestic situation, vulnerable individual, female, those types of issues. And as you know, we always will get pre-sentence reports whenever we are sentencing with regard to these types of offences. And the sentence does, of course, have to look at the totality and the complexity of the situation. There's no doubt that short custodial sentences do not work and do not address the issues that need to be addressed and the behaviour that needs to be addressed in these particularly complex situations. So whilst I understand why in some situations victims perhaps feel a little bit frustrated that it's not just immediate custody. There are, of course, a lot of cases where that is the appropriate sentence to have immediate custody, but there are other situations where it is more appropriate to strive to look, can you change that behaviour? And that's one of the reasons why the perpetrator programme would be so valuable in trying to actually get people to confront and address their issues, because all of these individuals are going to, even if this relationship has finished, they are going to go into other relationships. And we need to break the cycle of continuing serial abuse. And I quite appreciate the frustration. We have to look at each case on its merits and what is needed for each individual case. But of course, a strong message needs to go out that it's not acceptable behaviour and it will be punished accordingly. But we have to see the whole picture as well and try and address that picture for everybody. Anything else anybody wants to ask?
I think that might be it. Can I ask you all to thank Judge Bagnall for giving us her purpose? Thank you.